Hey, what's up, everybody? Welcome back to the Court of Random Opinion. My name is Lauren Neidigh, and I'm here with a quick update for you this morning on the Blake Lively versus Justin Baldoni court saga. Now, last night I put out a video reminding you guys that the parties were due to report to the court today whether or not the court still had something to rule on regarding the subpoenas, which Justin's side have called invasive and overbroad. Now it seems that, to no one's surprise, really, the judge will, have to rule on this. Let's go over what the attorneys had to say this morning. Give me just a second. Okay. Dear Judge, as counsel for Wayfarer Studios LLC, Justin Baldoni, Jamie Heath, Steve Sarowitz, It Ends With Us movie, Melissa Nathan, Tag, and Jennifer Abel, collectively the Wayfarer parties, and in compliance with the order dated February 19th, we write to advise the court that a dispute remains with respect to subpoenas issued by Blake Lively and Ryan Reynolds to cellular providers AT&T, Verizon, and T-Mobile. The subpoenas. Sorry guys, I keep getting comments about Mint Mobile ads on YouTube. I don't plan for that. It just happens. I don't get to pick my ads. I don't know. All right. The parties met and conferred via telephone on February 20th concerning the scope of the subpoenas. As a result of that meeting, the Lively parties agreed to withdraw their request in the subpoenas for A, all documents, B, data logs, and C, cell site location information. Okay. However, they refused to withdraw the request for call and text logs, regardless of whether those logs revealed when, how frequently, and with whom the Wayfarer parties, their employees, and various non-party individuals communicated. For instance, if the cellular providers produce call and text logs of all phone numbers with whom a Wayfarer employee communicated, the Lively parties will be able to use a reverse phone lookup function available online and through private investigators to identify every doctor, medical practitioner, lawyer, relative, friend, and any other person with whom that employee communicated, regardless of whether such communication was related to the claims or defenses herein. So let's hope nobody was secretly meeting up with anyone from Grindr. All right. Given the Lively party's representation to this court that they merely want to ascertain when and how the defendants and witnesses learned about Ms. Lively's harassment allegations, and whether, when, and with whom the Wayfarer parties discredited Ms. Lively through the press and social media, we suggested that the Lively parties limit the subpoenas to seek call and text logs between specific phone numbers of parties and witnesses. Unfortunately, the Lively parties rejected that reasonable proposal and have stated their intention to serve modified subpoenas to the cellular providers that still improperly seek call and text logs revealing the phone numbers for anyone with whom the Wayfarer parties, their employees, and various non-party individuals communicated. Good morning, everybody. I'm just seeing your comments coming in here. Okay. The Lively parties have not and cannot explain why they are entitled to ascertain A, the identity of each person with whom the Wayfarer parties, their employees, and various non-party individuals have communicated, B, how frequently they communicated, and C, when they communicated. Courts routinely reject such overbroad discovery requests. And you guys know I'm not a lawyer, so I'm just a random person here, which is called the Court of Random Opinion, so I'm not going to go over all the case law stuff. All right. I will read this part right here. It says, the request for every incoming or outgoing text message without regard to parties involved or subject matter content of the message is patently overbroad, as it calls for information that has no conceivable relevance to any claim or defense in this matter. In short, as drafted, plaintiff's subpoena is grossly overbroad, not proportionate to the needs of the case, and amounts to an unabashed fishing expedition. So they're citing a case there that said that. They're not writing that. Okay. And then here is another one, granting a motion to quash. Let's see. Yeah, we'll go ahead and read that. Why not? Granting a motion to quash subpoena to AT&T for plaintiff's personal cell phone records, including call logs, and text messages for an extended period of time because defendants have not shown any reason that they should be granted unrestricted access to plaintiff's entire personal cell phone records during the time period specified in the subpoena. And then here's another one. It says, the fact that the telephone records contain relevant information and are not privileged does not mean, however, that they are subject to unlimited discovery. The records undoubtedly include substantial data not pertinent to any aspect of this litigation. including information about personal phone calls. This raises significant privacy concerns. All right. Indeed, even in a criminal matter, which this case is not, a demand for jail calls and logs extended beyond the bounds of relevance, admissibility, and specificity, and was deemed a fishing expedition prohibited by the federal rules of criminal procedure. Okay. So even in a criminal case, this was like too broad or too much of a privacy concern is what they're saying there, I think. And this is not a criminal case, obviously. Accordingly, even if narrowed to call and text logs, the subpoenas are still overbroad on their face. Okay. And that was it. It's not much of too much of an update this morning, guys, but just to say, basically, yes, there's still dispute over the subpoenas. They did not come to an agreement on that. Basically, Blake's parties agreed that they would withdraw the part in the subpoena about all documents, data logs, and cell site location information, but they're still seeking like an overly broad scope per Justin's parties. What I'm going to do is I'm going to upload this document if you guys want to kind of pick it apart and take a look at it. Let me show you where I'm going to put this. So this is my X profile. Let me go ahead and upload that right here. Don't know if I want to put like a Dropbox link or if I'm able to do that. Hang on, let me see. I've never tried to upload a document directly. Huh, looks like it might work. No, I don't really see anything. So let me put this in Dropbox real quick. And then anything else that comes up throughout the day, guys, I'll give you guys updates. Tomorrow is the due date for the response to the protective order proposal. So maybe it'll come out today. Maybe we'll have to wait till tomorrow. We'll see. I'll put a link to this account in the chat here. That way you can go to it and you can find whatever it is, you want to see document-wise. I'll start uploading stuff there too, like other stuff there too. So if you follow me there, you'll be able to see the documents. I'll probably, do my live, do my video, whatever, and then post the document. So yeah. Wait, okay, hang on. Introverted Giraffe says, so someone sends a spicy text to their partner and it's discoverable. Heck no. All right, guys. Thanks for joining me. And I got to get back to work now. And like I said, I'm going to upload this to X. The actual docket entry was on Court Listener this morning, but I didn't see the actual document. So I did have to buy it off of Pacer. So if you want to actually see it, don't buy it. Just go here and you can see it for free. All right, I'll talk to you guys soon. Bye, everyone.